for all of us and took that fight out of the picture, because it was, people would spend an awful lot of money fighting about that and things like that. And so I'm glad that we took care of that too. The right to be designated as an emergency contact. I see this one probably left in and taken out in sole managing conservatorship cases, because, and also the one before that too, because you have someone who has supervised only visits. You don't want them to be exercising outside of what the court has given them. But also the right to consent to, the right to be designated as an emergency contact. If you have someone who's supervised visits only, well, you don't really want that person to be contacted to come pick up Junior, because they're not supposed to be doing that anyway. The right to consent to medical and dental and surgical treatment during an emergency, well, that just makes sense, doesn't it? Being able to take your kids to the doctor if they break their arm without having to go talk to the other parent first. And they go, that goes hand in hand with the other duties that are listed out, the duty to inform the other parent about significant events involving health, education, and welfare. And then, of course, the right to manage a child's estate to the extent that it was created by that person or that person's family. If dad starts a 529 fund, or his parents do, the grandparents, then someone should have the right to control that, one of the parents.
And then we have another breakdown of specific rights and duties for what a parent would do when they have the child during their period of possession. Can you talk about those a little bit?
Sure. And these are more of the, hey, go be a good parent type duties and rights, and take care of your kiddos. And the duty of care, control, protection, and reasonable discipline of the child. Take care of your kids. That's I really do my very best to try to, I say, I'm going to use the term dumb things down for people, but just speaking plain language. And so I think that's just being a good parent. Do to support your child and provide them with food, clothing, and shelter. That makes total sense, right? And the right to consent for the child to medical and dental care not involving an invasive procedure. Now, here we are again with a third different type of a medical right. And this one is, okay, your kid's got a cold. He needs to go to the doctor and get some medicine. And so, of course, parents should have the duty and the right to do that as well. And so, and the right to direct moral and religious training of the child. I don't really see this one thought about too very often. I have had some cases where the parents were of two different religions, and they were, and got so far so they couldn't come to an agreement about how they were going to raise their child. And so they were raising their child with two different religions, two different households. And I think that's a difficult position for a kid to be in. I've never really sat down. I've done some amicus attorney work, and I've never had that role in talking to children about how they feel about those types of things. But I think that I can see that there would be a concern with that right, and kids going in different households, being in different households.
Yeah, it's been a little while since I saw a fight about that issue, but I think for a lot of people, it's really important. And it can be the reason they split up to begin with, was difference in religious views. So then how are they going to deal with that with their child?
Absolutely. I had a case where the parties were the dad. They got married, and the dad was an Orthodox Jew, and the mom converted to Judaism. And when they got divorced, dad moved towards Christianity, and mom stayed as an Orthodox Jew. And so it really caused it a divorce, quite frankly. And then it caused this. That's where the last place I saw this particular right come up. And I can imagine how difficult it is for the kids, with the parents not being able to reach some sort of an accord in that situation.
So you already touched on this a little bit, but I think it's worth going back and talking about it a little bit more specifically. The duty to provide information to the other side. I see this come up a lot as a problem where people don't, especially when they have a lot of conflict, they can't communicate well with the other side. Every time they do give information, it's a problem. And so they don't want to provide information. And I think the, standard language is written in such a way that it's supposed to tell people what to do. But I don't know that it really does a very good job of that.
I agree. I think that what the code does a good job of is making sure the parents understand that they have some things that are very specific that you have to tell the other parent about, which is cohabitating with someone who's a registered sex offender. There are notice provisions in that, as well as someone who's the subject of a protective order, or a parent residing or being around someone who is, and this is fairly new, obviously, or apparently, but apparently, excuse me. And so those are incredibly important. I mean, and I have seen this come up where someone resides with a sex offender. It's one of the searches that we do whenever we're staffing a case and there's a paramour on the other side, or even my client's paramour. It's probably come up a handful of times in the last 14 or 15 years. But I think that's information that parents need, no matter what you think about the other parent. These are your kids, and so you should definitely have the duty to disclose that information and have the right to receive it, for sure.
One of the examples of something that I've had a parent not want to disclose is related to, okay, Johnny has an annual checkup at the pediatrician, and they don't want to tell the other side about it because they don't want the other side to show up and cause a problem. And then they don't want to tell the other side that it happened because they don't want to cause a problem for not telling them to begin with. When there was nothing particularly noteworthy about the appointment, it was just a checkup, everything was fine. And they say, well, that's not significant information. What would you tell a person that was having that issue?
I think that anytime a child goes to the doctor, that's significant. If a child has a runny nose or a low-grade fever and you're giving them Motrin or what have you, now, is that significant? I think that's probably a different story. But I go to all of my kids' doctor's appointments, and I like to know what the progress is. If we're talking about a well-child checkup and what the growth is, and I think that I think the parents should do that if they can. The parent who is concealing that information or what happens there, I think that's probably an indicator of a much bigger problem, usually. And but it's, man, I said it a while ago, and I say it tongue in cheek, but it's unfortunately true that parents just, when they can't get along, it affects their kids, and it's parents. There are certain things in life that you should do together for your children, and medical care and medical treatment and their education are at the top of that list, in my opinion.
I agree 100%. So let's go through some of the rights and duties individually that we see all the time, obviously, in our practices, but what some of the problems are and what some of the issues are that maybe we can help fix in how we're crafting orders. The first one, and I think this is one of probably the most highly litigated among the rights and duties, is the right to designate the primary residence. Talk to us a little bit about that.
Sure. So this is what, in Texas family law jurisprudence, we don't use the term custody. We use the term conservatorship, but this is what people call custody. This is what I always tell potential clients that come in my office, is that you don't want custody. You want the right to know where Junior's going to lay his head down at night most of the time. And so I agree with you. It's absolutely the most litigated rights in our world in custody litigation. And so it is also further complicated, and even more recently now, by what that looks like with a geographical restriction. And what we're talking about is, like I said, where does kiddo lay his head at most of the time, and what does that look like outside of what does the possession schedule looks like? It all ties in and runs in together. But again, complicated by the geographical restriction. With now it's under 50 miles, 50 to 100 miles, and then over 100 miles. That is what people call custody.
This episode of the Texas Family Law Insiders podcast is sponsored by the Draper Law Firm, providing family law appellate representation for non-parent custody cases, jurisdictional issues, property division, standing, conservatorship, possession and access, termination, parental rights, and grandparent access. For more information, visit draperfirm.com or call 469-715-6801.
So another one that can cause some disputes is the right to consent to invasive procedures. What constitutes invasive?
So I think that is still subject to interpretation. And prior to this podcast with you today, I've asked that question. We've researched it some. I don't think there's an absolute clear-cut answer. The Health and Safety Code gives a definition. It's kind of long. But I've seen some courts of appeals that kind of that cite this, obviously. And it's an invasive procedure means a surgical entry into tissues, cavities, or organs, or repair of major traumatic injuries associated with any of the following: operating or delivery room emergency department, cardiac catheterization, vaginal cesarean delivery, the manipulation, cutting, removal of oral or perioral, I don't know how to say that word, tissues, including tooth structure and things like that. And so I have described this as if it pierces the skin or if it pierces the body cavity. And so, it's certainly subject to interpretation. I had a case where one of the parents believed that a young child, a 3 or 4 year old child, was constipated a lot and was giving that child suppository. Is that an invasive procedure? Oh, man, I don't know. And of course, the big one, right, since March of 2020 and thereafter is COVID and COVID shots. And this, obviously, we've seen litigated a lot. And I don't think that there's a bright line rule for it. I've filed temporary restraining orders, and I've had some judges grant them and go in and have a hearing about whether or not the kid should get, have the vaccination. I have litigated the issue and had judges. I've had them both ways. I think right now it's just been depending on who your trier of fact is on that issue. But if you look at the definition from the Health and Safety Code, does a vaccination, is it a surgical entry into tissues, cavities, or organs? I mean, I think it is, but I've also litigated dental work and tubes in ears and things like that. And so I think that there's still a lot of law left to be made by the courts of appeals involving this particular right.
Yeah, I agree. And with the way it currently is, judges have so much discretion. So really, when parents can't agree, should we get our kid the COVID vaccine? Mom says yes, dad says no. It's how does your judge feel about it? And that's what's going to happen. And I don't think that's right.
I agree. Some standardization of that would be most helpful to parents in Texas and to us and our ability to try to help our clients make good decisions about these things.
So another one we see a lot is the right to consent to psychological and psychiatric treatment. Talk to us about that one.
Sure. So I mentioned I have a psychology degree. I always say that it's a bachelor's degree, so it qualifies me for nothing in the psychological world, except that it gives me kind of a social science of minded approach to things. I think I never could have guessed as a young man and prior to becoming an attorney how often kids would see counselors and therapists and need psychotropic medication. And then in our world, I don't know about you, but it's probably 1 out of every 3 cases that I have that kids are in counseling or need, they have problems like ADHD and things like that. And specifically ADHD and medicating of the same or therapy, that comes up quite a bit. Do we use Adderall or do we not? Or do we use some sort of counseling or therapy? It does come up a fair bit. And so I think that's whenever you have a child's mental health at issue and you have parents who are warring with each other, I think the child just suffers in my experience and what I've seen whenever the parents either can't make those decisions or don't have a vehicle by which to come to a resolution.
And so with both invasive medical and, right to consent to psychological and psychiatric treatment, a lot of times what we see people putting in orders is some sort of a tiebreaker. And what are your thoughts on including tiebreaker language versus giving the right to somebody exclusive? I know it could be a deal breaker for people where we're not going to settle unless I'm included in this right. And I think that's why people include a tiebreaker. What do you think about that?
So, yes, over the years, I think that the language that I've used in making tiebreakers has kind of evolved. We used to say, you guys have the joint right to make this decision, and the tiebreaker is the pediatrician. And I think we probably even early on used to put that language. I kind of like that. And it's evolved over the years. Now, so let me back up. And so one of the things that I ended up seeing was I actually had a doctor call me one time and say, look, I know what this order says, but I'm not doing this. I'm not making this decision. And so calls like that, as well as some other rights like education, things like that, these third parties don't want to feel like that they have the responsibility to make the decision. But what these third parties do all the time is they make recommendations. They take my kid to the pediatrician. I say, Doc, what do you think about the COVID vaccine? doc said, I recommend that kiddo get COVID vaccine. So now when we write our orders, we say, you will follow a doctor's recommendation. So now, and make that an order. And so now the doctor's not in the middle so much as he's doing the exact same thing, or he's doing the exact same thing she would have done before, but the parties are now bound by that. And so that's still currently how I draft joint rights, the joint right to make medical decisions.
So the other big right that we see litigated a lot, I would say, is the right to make educational decisions. And I've heard a lot of talk about why educational decisions need to be exclusive to one parent or the other, and problems there are if parents don't agree that a no from one parent means a no for all. Tell me what your thoughts are on that.
So, and the right to make educational decisions includes a component of choice of school, and it can, I should say, and it also ties into the geographical restriction. And I don't see this litigated too often myself. Like the choice of school, obviously, but not. So, for instance, if a child needs to be, some of the topics that can come up are whether or not a child needs to participate in 504 services, whether or not they're going to be in AP or dual credit classes, whether or not they're going to be held back, whether they're going to go to private school, public school, things like that. Those are some of the topics that I've seen litigated over the years, or certainly that were at issue. And if you're doing joint managing conservatorship and you're doing the joint right to make these educational decisions, then what I've done in the recent past, over the past 5 or 6, 8 years, something like that, is, again, just like with doctors, we used to say, you'll follow the recommendation of the school counselor. Well, I had a case one time where that was what it said, and I subpoenaed the counselor from the school district, and she came down to the courthouse, and we were all standing in the outside the courthouse, the courtroom. And I said, okay, so what do you think? What's your recommendation? She goes, quite frankly, it doesn't even really matter what I think or what I say, because we don't do that. You guys put this stuff in the order without ever talking to us. And what we do is we get together with this child's teacher, the principal on the campus, and the counselor, and anyone else that we think is important. When we put a committee together, and with the child, depending on their age, obviously, then we make the decision. And so that was a light bulb went off for me. I'm like, wait a minute. We're a whole bunch of really smart people, otherwise we wouldn't be lawyers. And so why in the world are we putting this information in an order without having consulted with these educational professionals? And so now the language that we use is that the tiebreaker is the school district, by the formation of a committee as determined by the campus administrator. And I've used a couple different iterations of the language, but really trying to mimic what that counselor told me that day. Because really, they don't. One person who's not a parent of a child doesn't want to have to make a decision that affects that child. That's the parent's job. And so I like the language. I've run it by some educators, and they appreciate what that, as opposed to what we were doing before. So that's kind of where, over the years, my drafting of that issue has gone.
Well, I like that. I've never heard that way of drafting it before. So I think we'll need to. I may need to borrow your language.
Of course.
Okay, so shifting gears a little bit to talk about enforceability related to rights and duties and powers. Are the rights and duties as written in the Texas Family Law Practice Manual enforceable?
No.
Why not?
Very short answer, no. And without getting too deep in the weeds about case law and ex parte slaving is how I've always pronounced it. I've heard people say slavin, which is a case from the late 60s. When orders are drafted, they are supposed to be drafted in such a way that they include order language or decretal language or command language, as we call it, such that a person is put on notice of what their duties are, what the court has told them they are supposed to do. Our rights and duties they don't have any of that. And so there's the two main things that we enforce. And the whole goal is to give teeth to what the court is saying you're supposed to be giving. And by teeth, I mean, can I get somebody in trouble because they went and got a COVID vaccine when it was a joint right and the other parent wasn't notified? How do I stop someone from doing that? And so right now, the way that the Texas Family Law Practice Manual states that we draft these rights and duties there aren't any teeth. And so obviously there are two big things in family law that we certainly can do something about when someone's not doing what they're supposed to be doing. You don't pay your child support, you can go to jail. You don't turn your kid over when you're supposed to, or return your kid when you're supposed to, you can go to jail. And so my thought in developing this topic was, why aren't the rights and duties that way too? If it's so important, if the trajectory of your child's life can be changed by an educational decision, eventually changed, why can't we stop someone from making those bad decisions? Now, the be-all end-all is you can file a modification, ask for custody, and ask for the exclusive right. But once the damage is done, how do we stop it from happening again? And so that was kind of where I started with this topic. And so putting that command language or finding a way to put some sort of command language into these rights and duties is kind of where I ended up. And I think it's possible. I talked to some of the brightest minds in our world, and I think there's I have some examples of that. And I don't know if it'll catch on or not, but I am shared this information with the people who draft the form book and the committee that does that through the state bar family law section. And maybe it catches on. It's going to make our 40 some odd page divorce decrees, 50 some odd pages, probably because we have to have that language. I think it has to be with every single right. There has to be a section that puts this command language in such that a court can hold someone in contempt for not doing what they're supposed to do.
I never thought about it before, but in listening to you talk about that, if I'm looking through the family law handbook or something for information on enforcements, it lists a section for enforcing child support and it lists a section for enforcing possession and access. Mm-hmm. And it doesn't talk about at all enforcing rights and duties. But if we don't have a way of enforcing, if let's say I'm supposed to have joint decision-making with regards to an invasive medical procedure and my ex, I don't have an ex, but let's say hypothetically that I did, my ex, gets the child surgery and doesn't tell me about it. If I can't enforce that, what good is it for me to have the right to begin with?
Well, and a hot topic, so to speak, right now in Texas family law and throughout the United States, and people have very, very strong views about this topic, but, transgender issues with children and the decisions that go along with that, the operations and the type of drugs that can be given and administered to children. There's a big case up from your area that has been litigated in the Court of Appeals now that involves things like that. And so, if a parent makes a decision that's irreversible, what do we do with that under our current state of our rights and duties that are in the family code and the way that we're bound typically to draft them by the Texas Family Law Practice Manual? The parents can't agree on that topic. And so I don't have all the answers, but certainly something more could be done to dissuade parents from making these important decisions without including the other parent or following the order.
So with the way things are now, what can we do to make rights and duties more enforceable? So
I propose, essentially, in broad strokes, what I propose is that we make them injunctions. We put language after each right and duty. So the joint right to make educational decisions, we give that to the parents jointly. We have a tiebreaker. I think it's important that you have agreements and make them in writing. Then you not only do you give the right to each parent, but you also enjoin them from making the decision without the other parent. So now if dad takes kid to the doctor and gets him a COVID test and mom didn't, or COVID vaccination, and mom didn't want him to have the COVID vaccination, well, now you're in a position to go to the court and get some relief, just like you can on other rights, other things that you have in our orders. And so, and if we're doing our jobs as litigators and as practitioners, we're telling our clients, look, don't go do this because you can get thrown in jail. And, I see a lot of orders from other states, and maybe you have too, where the order just says, all right, mom gets legal custody and mom gets physical custody. Dad's got some visitation rights that are seem like they move back and forth. The parents will agree to what visitation is. What I appreciate about what we do in Texas is that we make our rights rights specific. We make our possession schedule specific, such that we can go and do what I'm talking about, which is go back to the court, get some relief, and hopefully dissuade the other parent from not doing what they're not supposed to do. So I think injunctions are the answer in this.
Yeah, and that's something I've never seen anybody put in an order. I've never seen anybody bring it up, but I think that's an excellent idea of how you make this enforceable and how you keep people from doing what you don't want, what you fear that they are going to do. And it may not be necessary in every situation when we have parents that are, relatively amicable or seem able to co-parent. But when you have, the parent who vehemently wants the COVID vaccine and the parent who vehemently does not, unless you have an injunction or something in there, there's probably not a lot of recourse when one parent acts contrary to what the other wants.
Right. And I always tell my clients that I can't stop someone from doing something, but in the big instances with child support and possession and access, there's something we can do about it. If it's possession and access, we can get makeup time. They're always subject to attorney's fees. And these, as important as these rights and duties are, not having that same ability, when I started thinking about it, seemed a little crazy to me because, I guess one could argue, minds could differ about whether or not the COVID vaccine issue is more important or less important than whether or not the kid gets to, go to dad's for the weekend or something like that, or whether or not dad's paying half or mom's paying half the child support, not the whole child. So I think before that, rights and duties were just something that we just all put in there, we just all did, and then the parents could take their order and wave it around to the doctor or to the school and do what they get what they wanted. But as we've seen these rights be ignored or abused by parents, it seemed to me that there's something that we can do about it in the way we draft our orders. And maybe there's a better way. And if there is, I hope whoever sees this calls me and tells me about it. But this is the best that I could come up with. And some of the brightest minds in the business that I've talked to think that this might work. It might be a good way to do it. I haven't done it yet. But I know there were a couple of, when I did this presentation before, a couple of judges that were in the audience that came to me afterwards and were like, okay, well, I can see where that might be important. So I'll be interested to try it for the first time and see what that looks like.
So normally when we put an injunction in, we have that standard language, because of the conduct of the party, this injunction is necessary. So let's assume that there hasn't been anything in the past where, a parent acted directly contrary to what the other parent wanted. There was no one parent taking the child to get an invasive medical procedure. There was nothing like that in the past. We're just trying to protect it in the future or, keep problems from happening. If both parties don't agree to include it, do you think a judge can in that situation?
I don't know the answer to that. I hadn't really thought about that specific instance yet. I'm not sure. I know that, I'm thinking out loud here, but if a judge says because of the conduct of the parties, maybe the judge sees that these two people cannot get along. They cannot co-parent. And if that trier of fact decides that, look, this is going to be a problem, and maybe it's their conduct in other ways that makes the judge believe. So I think I'm shooting from the hip here, but I think the judge probably could. If you see mom and dad and you see what they're doing to each other and burning their stuff on the front lawn and slashing tires, all kinds of stuff, I think you could use any conduct to make that determination. And so then we get into the waiver of service and that stuff too. Obviously, if it's agreed, then you can waive service, but service of writ. But then you have to go through that part of it as well, which I can't think that I've ever served a writ on someone for injunctions because they either always agree to it or I guess we've just never come up. But that's just another step I think you have to take.
Yeah, I think it's an interesting thing to consider. And I guess by virtue of the fact that these people made it to a final trial to begin with, probably says they're not very capable of co-parenting and maybe therefore they are worthy of such an injunction in their final order.
Yeah. And then, I would assume that if this catches on in any way, then, you're going to have that issue litigated and appealed. And then, we'll start, the courts of appeals will just start weighing in on these issues, and we'll see how that goes. Like I said, if this kind of catches on, but I racked my brain trying to figure out the best way to be able to put some teeth into this. And this is what I've come up with. And so to me, it feel like it's my own little pet project, and so I'll be interested to see if it catches on. The first time I go try to do it in a contested hearing, what a judge is going to say.
Well, I certainly think it's an excellent idea, and I know that I intend to start trying to incorporate it by agreement in our orders, because people are always, we want to make everything enforceable when we can. We want to try and prevent problems in the future if we can with everything we're putting into an order. So if this is a way that we can create enforceability and we can hopefully prevent problems from occurring in the future, let's do it.
Yeah, and I will tell my clients, and I will tell, I would hope that my colleagues will do the same whenever we're drafting these orders. I would say, look, this is what this says. And just like if you don't pay your child support or you don't take Junior back to dad, you could go to jail for doing something like this. And I think that if we educate our clients early on about that type of stuff, I think that especially the high conflict cases, they'll appreciate the fact that there's a way to get some redress if these orders aren't being followed. Now, is there a chance that it could be over litigated? Yes, of course. But there's a balance in there somewhere. I mean, everything's subject to litigation, but there's a balance somewhere, I think. And I really think that it will assist parents in making sure that what they agreed to is what's being followed, or what a judge orders is what's being followed.
Well, I like it. So we're just about out of time, but one question I like to ask everyone who comes onto the podcast is, if you could give one piece of advice to young family lawyers, what would it be? Know your rules. Stay on top of Court of Appeals opinions and Supreme Court opinions. Our practice shifts so much on what our courts of appeals say, and there's so many different issues in family law. Know your statutes, stay up on the legislative changes, and do your research. Have a background knowledge of everything, and just continue to stay up on it. There are lots of resources throughout the state for the most up-to-date information regarding legislation and case law, and find them and read them. I mean, if you look back to 2013 when we had In re Stephanie Lee, and what that did to our practice, and all of the projects that came out of that. So educate yourself. Go try to take the board certification test. Get your experience. I think I personally think it's vitally important. Some people and some of my colleagues have no desire to do it, don't want to do it, don't think it matters. But I guarantee you that I'm a better lawyer because I spent the time and effort to go educate myself and sit down and go take yet another exam. And I thought that I was only going to take one more. So educate yourself. That's the best advice I can. I always say that lawyers who come out of law school, they know more law at that moment than they ever will in the rest of their life. I know I did. But as you know, I know a whole lot, a little bit about a whole lot when I graduated law school and took the bar exam. And if you're not a general practitioner and you're focusing just on family law, well, treat that as a job and educate yourself. So where can our listeners go if they want to learn more about you? If you want to learn more about me, my website, jenkinsandkamen.com. I always tell people when they're asking for my office numbers, I'm not hard to find. You can Google me. You put Adam Dietrich, lawyer Conroe, and you're going to find lots of information about me. I am a member of several different committees for the state bar, and as well as some other committees and organizations that help try to advance our drafting, our legislation, things like that. And so that's the best place to find me. Just Google me. Well, thank you so much for joining us today. For our listeners, if you enjoyed this podcast, take a second to leave us a review and subscribe to enjoy future episodes.
The Texas Family Law Insiders podcast is sponsored by the Draper Law Firm. We help people navigate divorce and child custody cases and handle family law appellate matters. For more information, visit our website at www.draperfirm.com.